guys, it's Kathy. I hope you're doing well. We made it to Friday. Yes, we did. And I managed to piss off all of Australia. Yep, I did. Looking at the comments that I'm getting, the text messages that I'm getting, they're mad at me. Look, it's not my fault. I can't play the rebel trial. Okay, I can't. I'm not allowed. You go talk to your people in Australia if you don't like it, but yelling at me isn't going to do anything. It's not like you pay me to get it. Go find it yourself. But I do have it on my Patreon. You can just go there and watch it. You can. You can just click the button. The link's on my channel. And then you can... Everything I have is on Patreon right now. All of it. And I guess she had a baby, so her partner had a baby. So there's not going to be any more trial for a little bit, because they have a baby. That's not my fault either. I did not impregnate either of those women. So please don't comment about that either. I didn't do it. I said Australia, Brad. Oh no, they're mad. Angry emoji with the swear words crossed out. I prefer though that you don't cross out the swear words. You can swear at me, it's fine. It is fine. I hear swear words every day, especially from Josh. You should see how Josh is in mod chat. He swears at me every day. Like, no, he doesn't. He doesn't. He talks about food. All right. I don't think they do. I just think they want to see Rebel. I get it. It was a good trial. It was very interesting. But I'll put more on Patreon when I get more. It's the best I can do. Okay. Let's get busy. This is landlord tenant, kind of. No one's getting evicted. He just wants his water turned back on. A test? Oh. No, I didn't, Bobby. I'm not the father of either of those kids, although, Bobby, I make a damn good man. CJ would never bitch about me. And she's allowed to. I'm fine with CJ. She can say whatever she wants. She can swear at me. She can yell at me. I wish I could get more from Australia. I really do. I'd play it every day. Just to hear them say some of the words that they say is very, very cute. Especially when it's an intense trial and you're talking about, murder or whatever, and they say these cute Australian words. I don't know. Is it... Oh, I can barely see, so it looks green to me. I'm going to go with the birds. The eagles. But let's press play.
Both the city and Ms. Marnoka for the defendant are online. I'll start with... Mr. Rowley, are you here? You may have a seat at the plaintiff's table. I think I have Eliza Rowley who is online. Yeah. Is she your spouse by chance?
Yeah.
Okay. She's not a named party. I believe only you are named.
Yeah.
Okay. So I'll show Leo Rowley appears in person. And then you have someone with you, sir.
What is just my friend, right? Just support.
Okay. And you're welcome to sit there for moral support. All I ask, if someone is going to sit there, I would like their name for the record.
Wayne Mason, M-A-S-O-N.
Okay. And is Wayne W-A-Y-N-E? Thank you very much, Mr. Mason. All right. Folks, I remember this case. The plaintiff filed a complaint and the defendant, I believe, filed a motion to dismiss. Let me pull this case up. And I apologize. Ms. Marnoka, can you hear the court okay?
I can, Your Honor. Thank you so much.
All right. Thank you. And thank you for your patience. I figured the default judgments might be a little quicker than the oral argument. So I took you after the ones who had multiple cases. I apologize.
All good.
All right. So looking at the statement of claim, I will read through it. Mr. Rowley indicated, my mother passed away 11 months ago, and my nephew, who lives in Virginia, called the water company and had them shut off the
Right.
water to my home of 30 years because he was named executor in the will. But he has not filed probate, and it's been 11 months, so he is not technically in charge of the estate. He made a call to Waterworks, and they shut off the water and a copy of the will. He also took thousands from the bank account, which might be irrelevant to a
Right,
case.
most of that's irrelevant. I was just pressing for time, and I just had living on it.
Okay, I'll finish just for completeness sake, and took everything of value from the house, the property, all with a letter of administration from a judge. I have stage 3, 4 cancer, sorry to hear that, a healthcare risk, me having no water, and then, sorry, that continues on the back. My nephew lives in Virginia, hasn't filed probate. Now, man, let me take a break for a minute. You mentioned he hasn't filed probate, but you said he had a letter of administration.
No, I misdid that. He does not have a letter of administration of anything. I miswrote that. That's my bad.
I
You know what
agree,
mean?
Kit Kat. I agree.
he
with
doesn't
you.
have-
Let me ask you some pointed questions. Did you open an estate?
I can't, and without a probate attorney. And I've been trying, but I keep on running dead ends. But with my health and everything, I've been had to go without water, and I'd asked the water company. I went down there and I was going to pay the water bill. You know what I mean? Or the other option was for me to just get it the water in my name, right?
Well, who's the owner? Who's the owner?
Nobody right now.
Your mother's.
It's not.
Let me take a time out. You want to talk before I'm done with my
Okay,
question?
sorry.
I need you to sit back and listen and answer my questions and only my questions, or this is going to take 2 hours.
Okay, sorry.
Okay. Who was the named owner of the real estate at the time of your mother's death?
My mother and my father.
Okay. Did your father die before your mother?
Yes, sir.
So at the time of your mother's death, had the deed been transferred to just your mother, or did it still say husband and wife or the survivor?
And I think it said to both of them still. I don't think my mom took anything out of my father's name.
Did your mother have a will when she died?
Yes.
Did that will name an executor?
Yes.
Was that executor your cousin from Virginia?
Yeah, my nephew. Yeah.
Okay. So in my opinion, whether or not he opened a probate matter, he would be the authorized person to act on behalf of your now deceased mother. And if he is ordering something done regarding utilities, it would appear to me that the city is just obliging the authorized request. Ms. Marnoka, if you'd like to expand, I wanted to have this hearing for the benefit of the plaintiff to be able to explain and talk through this, so I didn't just dismiss the matter on paper.
That I totally understand and agree. Mr. Rowley, when he did bring sections of his mother's will and testament. However, he didn't include the whole thing. The whole thing, in its entirety, says disinheritance of children. And the mother specifically disinherited Mr. Rowley. That's the first thing. Second thing is Mr. Rowley currently has Class 2 felony pending and a Class 6 felony pending, one for possession, the other, I believe, for dealing and of methamphetamine. And he got a medical furlough on, I believe it was the end of March or the beginning of April. And no, it was the end of March, looks like. Anyway, he then just...
I know we were joking, but I really think he is wearing football jerseys under his robe. I just do.
Apparently he had a key to the home and just went there. The nephew provided us with a will. We do not turn water on or offer water service to someone who is not authorized to inhabit the home. So we require a deed in their name or else a lease. In this particular case, if the nephew had at the very least provided us with a written document giving permission for his uncle to stay in the home, we would have at least considered that. With the water bill, there's a water and wastewater component. Mr. Raleigh, as far as I know, is not employed. Again, he is awaiting a trial for 2 felonies. And his the second component, the wastewater component, what happens is if that remains unpaid, we can lien the property. That's why we have to have permission of the owner. You understand, we can't just let somebody move in there, run up this huge bill, and then we try to lien the property, and the owner who has the property never gave permission for that person to be there. So that's where we are in this.
Okay, let me go back and ask Mr. Rowley some more questions. And Mr. Rowley, at this time, I want to place you under oath. Do you swear or affirm under pains and penalties for perjury that the testimony you're about to give
That's exactly what he did, Sherry. You're exactly right.
will be the truth, the whole truth, and nothing but the truth? So help you God? You may put your hand up. Sir, what is your full legal name?
Leo E. Raleigh Jr.
And Mr. Rowley Jr., have you ever had a written lease which allowed you to reside in the property once owned by your late mother?
No, what it is she mentioned the will, sir, the will. It says dual tenancy, that means 2 people live at the same residence. With
Dual tenancy, but it also says a disinherited
right,
children.
But it was a side memorandum that my nephew is not bringing up. The whole family knows it because that's why I've been trying to get in probate court, because there's certain parts of the will it doesn't make sense, because it says at the time of her demise that she was a co-owner of the house and she should have been the sole owner.
Well, are you the other co-owner?
No, but I'm part of the dual tenancy part because I took care of my mom the last year of her life.
That doesn't give you rights in her real estate,
But
especially if her will says she's disinheriting her children.
But I was the last person living there. But even when all this other stuff happened, my nephew was in town and he wasn't trying to do nothing. In fact, he told me he was going to put it in my name because that's what my mom's wishes was. Okay, and we got this, and I went to other, trying to get a probate attorney to put it in probate, like you said, you know what I mean, to open it up myself. And they say this part of the will that it says that it just doesn't make no sense, because the dual tenancy part says that 2 people live in the same house, live in the house.
Who are the 2 people?
It doesn't say the names in it.
Okay, wouldn't that make sense to be your mother and your late father?
Well, but my father died 5 years ago.
Okay, but at the time the deed was issued, since you told me earlier it wasn't changed to just your mother, it would have still said mom and dad, right?
Right, but it
Okay, now let me stop you again. How do you come in? Do you have a deed or do you have a lease signed by your mom?
neither one. I've never had one. I've lived there on and off my whole life because I came there when my dad was sick and took care of my parents, and then when my mom was sick, I come there and took care of her the last year. And what she told me, what she said, right, was that I was supposed to be able to stay in the house until the day I die.
The day you died or the day she died?
No, the day I died.
Well, that needs to be in writing.
Okay. And that Josh had a piece of paper saying all that, and that he's not producing that part of the will. So that's why I've been trying to get it in probate court to make him do that, because the only thing he's only showing part of it. What it is when I got out, I went to the house. I didn't break into the house. I went down to the Elkhart Police Department and showed them the paperwork I had, because my ID and all my legal paperwork, everything I got goes there. And they said, we can't stop you from getting in. So I went in and I got in. I tried to call Josh and tell him and everything, and everything's going on. He won't talk to me. He won't do nothing. And all I did is went down to the water company and asked them, said, okay, can I pay my mom's bill? They said, no. I said, can I put the bill in my name? They said, house in my name. They said, no. I said, so what am I supposed to do? They said, we can't turn it on your
Yes.
name, you can't do this, we can't do
Mhm.
that. And I'm like, well, I don't understand because I got all the other bills in my name. And I've been paying them. All I'm doing is ask the water company to give me a chance to have the water put on it, pay the bill.
And I can't force them to give you that chance. I mean,
That's why we're in court today. He wants water. That's all he wants.
honestly, sir, you're lucky that your nephew in Virginia is not also seeking to evict you, because if there's no deed and if there's no lease, and if he's the executor, and if there's a disinheritance clause, it would appear that an eviction would be appropriate, but that's not set for today. The only issue set for today is whether or not the court should order the turning on of the water in your name or otherwise. And under the circumstances, I can't do that. I can't force the city of Elkhart or Waterworks Company to do something that they're not ordered to do by statute, or that there's no contract requiring them to do.
But, okay, but I'm saying I just don't get it because I'm willing to pay the bill just like everybody else. I'm saying, you know what I mean?
Let me give you an example. Let's say somebody signed a lease that went from January 1st of last year until December 31st, and they paid their rent every single month, and they thought they were a good tenant. But in December, the owner decided, I want to sell this property. I don't want to lease again. And the tenant said, but I want to keep living here. I'm willing to pay. The landlord would have the ability to say, I get it, and you're a good guy, but I don't want to release. I want to sell. In essence, that's what is happening. Your nephew is saying, I'm the executor. I don't want you there. I'm not going to authorize water. And quite frankly, maybe one day I'm going to evict you. I would, if I were you, start making plans to not be there, because I don't think it's a permanent solution, unless you want to hire a lawyer and be the one who files for probate, etc. But the short story for today, sir, is I need to deny your request for me to order the city of Elkhart to turn on the water. Ms. Marnoka, do you care if this closing of the case is on the merits after taking testimony, or if it's on your motion to dismiss?
I am fine with that.
I'll go with, having heard all of the evidence, all relevant evidence as I see it, there's no basis for me to grant plaintiff's claim, so plaintiff's claim is hereby denied.
Thank you, Your Honor.
Thank you all. Good luck to all of you.
Good luck finding a new place to live, sir, with water. You need water. I bet you that the nephew is thinking long and hard about eviction right now.
Case is the Trust of Shirley Kubo.
We're on the record for cause number 20D022603TR4. This is the Trust of Shirley Kubo. We have one person in court, two online. Can I have the people online identify themselves first?
My name is Tammy Zook. I'm the executor and trustee of my mother's will and trust.
Joel Dendu, attorney for the plaintiff and petitioner, Miss Lori Pierpont.
Okay, and then Ms. Pierpont, you're in court today, is that correct?
Yep.
All right. So I don't anticipate hearing from Ms. Pierpont today because she is counsel. But Ms. Zook, you're still unrepresented, is that correct?
Yes.
You raise your right hand for me. Do you affirm under penalties of perjury to tell the truth?
Yes.
All right, thank you, Ms. Zook. How are you doing today?
I'm better than last time.
Okay. All right. All right, Mr. Denadu, I think this is your case. I guess, can you tell me a little bit about it?
Oh,
Your Honor.
I thought I was muted that whole time. At least I didn't say anything. Denadu, that sounds like a fantastic last name.
This originally started when my client, Miss Lori Pierpont, who is a child and a named beneficiary.
So if she marries him, she could hyphenate it to Pierpont Denadu. That is an epic last name.
Of the trust. She requested both an accounting of the trust as well as an accounting regarding a power of attorney. Ms. Zook was the attorney, in fact, for the decedent and the settlor of the trust. When Ms. Pierpont requested those things, Ms. Zook did not provide them. Ms. Pierpont then hired me to send a formal request for an accounting. This was sent to Ms. Zook around June 30th of last year, 2025. No accounting or response was provided to that formal request for an accounting. Ms. Pierpont then hired me and paid me to file a complaint seeking both an accounting for the trust as well as an accounting for the time that Ms. Zook served as the attorney-in-fact for her mother. Ms. Zook was served with that complaint on August 26th. Still, neither accounting for the trust nor for her time as attorney-in-fact was provided. I filed a motion for default judgment on September 22nd, 2025, after the time for a response had lapsed. The court set that for a hearing, as well as set a motion for a change of venue, which was filed by Ms. Zook late according to the trial rules, but it had been filed. That hearing occurred on October 16th of 2025. At that point, I was finally given some documents, though my client, Ms. Lori Pierpont, still has issues with both the attorney-in-fact accounting as well as the trustee accounting. As the court knows, the St. Joseph County Court did grant Ms. Zook's transfer for venue, which is why we're in front of this court now. Your Honor, some relevant Indiana code cites 35.6.4. If an attorney-in-fact fails to deliver an accounting as required under this section, the person requesting the accounting may initiate an action in mandamus to compel the attorney-in-fact to render the accounting, which is, of course, what Ms. Pierpont has done here. The court may award the attorney's fees and court costs incurred in this subsection to the person requesting the accounting if the court finds that the attorney-in-fact failed to render an accounting as required under this section without just cause. Indiana Code 30-4-5-12 states, unless the terms of the trust provide otherwise, or unless waived in writing by an adult, competent beneficiary, the trustee shall deliver a written statement of accounts to each income beneficiary or the income beneficiary's personal representative annually. Neither accounting was provided. It was Ms. Pierpont had to hire me, had to pay a filing fee, had to pay another filing fee regarding the transfer of venue. There was no just cause. And finally, Indiana Code 30-4-311 states the trustee is accountable to the beneficiary for the trust estate. If the trustee commits a breach of trust, which unjustifiably not providing an accounting certainly counts as a breach of trust, the trustee is liable to the beneficiary for reasonable attorney fees incurred by the beneficiary in bringing an action on the breach. So just at the outset, Your Honor, what my client is seeking, we do have some documents now that could plausibly count as an accounting, and that still needs to be dealt with at a later time. But at least at this point in time, my client is seeking court costs and attorney fees as a result of an accounting just not being provided over and over again without justification.
Okay. Well, before I turn it over to Ms. Zook, so this...
She has no response to that. That attorney did a great job, and she's pro se. I wonder how this is going to go.
You may or may not know, too, and, is that this isn't the first time the parties have been in my court. And you're welcome to talk to your client about it. But treating this on its own, I guess, Mr. Denadu, the first hurdle in this is I think you just need to work with Ms. Zook on making sure you have all your questions answered and all your documents. As far as the attorney's fees, I'll consider a reasonable request, but when, to be honest, when you didn't file in a preferred venue, and you chose to file in St. Joe County, that's going to be an uphill battle to get your full attorney's fees. That's just a matter of research and reading the trial rules to make sure it was properly filed in Elkhart.
Oh, never mind. The judge got him for her. Tammy, you just sit there and shut up right now, okay?
County, and to have this properly served. The fact that it wasn't is not really on the parties. It's more a research issue. So I'm not going to stick the other side with those attorney's fees. That's really more of an issue between you and your client. But I mean, if there's a reasonable request, I'll consider it, but I keep that in mind. I guess, what do you, let's start with this. Ms. Zook, I've noticed that you filed quite a bit of filings on April 16th. Is that everything you have, or are there more?
No, I have a lot more. She was offered the, all the receipts, everything from the selling of the car, and she refused to come down to the bank. And now, then after the fact, she files a false PPO on me. It's just been an uphill battle with her.
Well, you don't have to talk about the protective order, because we already dealt with that in that protective order. What I'm concerned about here is making sure that all the documents have been provided, because we've moved on from that. I personally moved on from that protective. You both of you might not have. That to me is open. And so now the matter is making sure that Ms. Pierpont has all the documents that she wants to see, and then that pretty much deals with this loss, because this is an accounting. So that's the answer, is provide the documentation.
I did.
And so how cooperative you are, because you said you have more documents.
Well,
So
I gave the.
Just like the protective order, you have to let me finish.
Oh, I'm sorry.
Based on how well you work with
I had a nickel for every time I said that.
Mr. Denadu, is going to factor into whether I use my discretion to award at least a partial amount of attorney's fees to Ms. Pierpont for this lawsuit. Okay? Yes. So if you're cooperative, if you're working with him and provide him everything that he requests for, because I recognize that you're not an attorney, so you don't have the sophistication to provide an accounting that an attorney would provide. But you can still answer his questions and provide him with documents that he needs. That, you know, even if the more cooperative you are, the more that's going to benefit you at the end of this. Okay. And
I thought I was when I went over.
I'm not saying you're not, but what I'm saying is the way that this hearing is going to go is, my plan is to have you to do a status conference in 60 days, and if just to touch base. But if everything's resolved before then, we can see motions. We could file a motion with the court saying that Ms. Pierpont's satisfied with the accounting you provided, and then if Mr. Denedy wants at that point to file a request for fees, I'll set it for hearing and consider it. Okay?
Yes.
Okay. Will that work, Mr. Denedy?
Yes, Your Honor.
I have an attorney.
I can't ask a question.
No. All right. So that's what we're going to do. Let's set a date 60 days out.
I've already gave him everything.
Well, but you told me you have more documents. So
it's documents for the courts, but I have the text messages that I gave you that said that to meet down at the bank.
Okay, that doesn't need to take up court time. That's something you could reach out to him in the next few days.
I already did.
And ask him, give him a chance to review what you filed. And say,
I gave it to him personally, or his secretary.
Okay, but you need to then have a conversation once he's read everything to then let him ask follow-up questions and see where you're at, okay?
This was months ago.
All right, you can fight with me on it, or you could...
No, I gave him the documents months ago.
I understand that, but now it's in front of me and I can actually have a say, and this is what I'm not going to resolve this today. Because Mr. Denadu said when he told me about his side of the case that he's not sure yet whether he has everything he needs. So he needs a chance to review that and figure that out.
Yay, Bobby's on a Twitch streak.
And I agree with him in his position. If I were in his position, I would say the same thing. Because sometimes you get documents and then you're like, okay, I have them all, but then how do I make sense of this? So that's part of and it's because you didn't live through it. When you don't live through the documentation, sometimes you have questions about it. So what do we have, like 60 days out from
We could do June 22nd at 9:15 or 2 o'clock.
now? So June 22nd at 9:15 or 2 o'clock, Mr. Denadu.
You're Monday the 22nd at 9:15 works for me.
Ms. Zook, does that work for you?
Yeah, it has to.
Mr. Bott, does that work for you?
Sure.
All right, and WebEx is permitted again. And what I'll look for here is if something isn't filed first, we'll just deal with it as a follow-up status to see where we're at. But I hope if there's some motions or other things done, or if the answers are all there, that it's resolved by then. But this will at least give us a placeholder. Any other questions, Ms. Zook?
She's wanting the inventory of my mother's house when she went into the house and took whatever she wanted, including there's no list no more, that I spent 4 hours making the list because we didn't have Wi-Fi. So if she wants everything that was in my house other than what she took, because I got an egg slicer and a box of cards, she can have everything that's in storage that I've paid for the last year, because I did not have an estate sale because she went over to the neighbors calling me a CUNT and my husband a BIT.
All right, look, we're like, again, this is not productive.
I don't know what to do about the inventory because she's got the list. She took all the whatever she wanted out of the house. I had to run over to the house. Everything's in storage so we can work on the house. If she wants it, she can have it. I don't want anything else.
Accounting is not this isn't an estate proceeding. This isn't.
That's one of the things that she requested.
Demanding things from each other. This is just asking for information. That's all this is.
And I thought I gave it to her.
Action for accounting is asking for information. So based on how well you work with Mr. Denadu, it's going to determine how this ends up. Okay?
Okay, my egg chopper, it's a chopper. Yeah, you just smack the top and it chops it. Is like one of my favorite things in the kitchen ever. So I don't want an egg slicer though. I have my egg chopper and I love it.
But he's not requested anything. He's not gotten in contact with me.
You're going to reach out to each other and talk about it.
Okay.
So set up an appointment with him, and then you could reach out and then have a discussion to make sure, or do it by email. Ask him if he has everything he needs. Whatever works to have a word that enables you to communicate with them. But that's what I want you to attempt.
I have one question. She's saying that I was power of attorney while my mother was alive. It was Lori Pierpont and or Tammy Zook. I took over when I found out what was happening with my mom's bank account on November 1st, and I gave him those documents too. So before that was Lori.
Okay.
I mean, I don't know what else to say.
Well, this is really about the accounting, not so much.
Well, no, the accounting for the Pierpont, they're saying that I was the POA the entire time, and I wasn't.
Well, so even a POA that shares those responsibilities.
I'm responsible for what she did?
No, you're responsible for what you did.
Okay.
So if there's an accounting for your actions, then you need to account for that. Just like,
and I did.
Okay. And
yes.
The answer is, I didn't handle that. The other POA did. That's your answer. You don't have to make up answers.
Okay.
Okay. Okay. Mr. Dendu, any questions from you?
No, sir.
All right. Thank you. Thank you both. Let's get this back on track, and hopefully we'll have a clearer picture on June 22nd.
We do not have a clear picture right now. I don't even know what's going on.
Thank you, Your Honor.
My clip says there's still 2 minutes left. So I think something happens. I don't know though. Oh, yes, I do know.
Oh, so you can sit there and talk to the judge.
Tammy,
Yeah.
what I said was she can't talk to me.
But why is she sitting in there for?
She came to court, said a WebEx.
I mean, so why am I doing WebEx and not in the court?
You could have came to court.
Oh, I thought it said WebEx because the letter
WebEx
that
is permitted.
her
So
lawyer
WebEx is,
sent me.
so WebEx is permitted.
Oh,
You
okay.
still come to court. And what I just told her, which she could tell you too, is I just told her I wouldn't
No, she
talk to
won't.
her because she has an attorney.
Yeah.
Okay.
Yeah.
Magic the Gathering
I'm
cards are
just,
expensive.
this is going to last forever with her. I already know it.
Well, it doesn't have to because both
I
of you
mean,
guys.
I don't know what else she wants because if she wants my mom's belongings,
Looks like you want contempt. You need to shut up when the judge is talking.
she got everything that was
Look,
worth it.
Mr. Dennett is off the phone call, so I can't really
I
continue
know,
this.
but I mean, I can't afford a lawyer. And I'm not, you know what? I go bankrupt before I pay for her lawyer with all the stuff she's done so far.
All right.
You know, we got
Yeah,
criminal cases and everything else because of her.
I wonder if she's...
WebEx on June 22nd. You can appear in person if you want. So when I say it's WebEx, it's optional. Okay? All right.
Thank you.
Yeah, thank you.
Ugh, what a mess.
Would you happen to know what time it is?
10:16.
10:16.
10:16. All right, let's do a golf cart. A golf cart.
So the plaintiff appears in person, defendant fails to appear. This matter was continued previously from a hearing originally scheduled in January. It was continued on request of the defense. Defendant was sent a notice of the rescheduled trial to the address on the notice of claim. There's no indication that defendant's copy was returned as undeliverable. We'll show the defendant fails to appear.
I love
Mr. Johnson, are you
it.
prepared to go forward?
I just love it.
Yes. If you would please raise your right hand and be sworn in. Do you solemnly swear or affirm the penalties for perjury that any testimony you give will be the truth, the whole truth, nothing but the truth? Thank you, sir. Please feel free to have a seat. Mr. Johnson, having read the notice of claim, I am aware of at least the basic nature.
They look comfortable. Those court chairs, the audio is not great because it echoes off all the walls, but the chairs look very comfortable.
Of this sounds like there's some damages that you're claiming relating to a golf cart striking a vehicle. Tell me about what's going on.
Yes, on June 1st, 2025, approximately 7:52 p.m., we were sitting in our living room, heard a loud bang. We ran out front and saw that there were two juveniles that had just gotten off the golf cart that had struck our vehicle parked on the street. Following that incident, multiple people came out to the scene, saw who the individuals were, knew the parents. They contacted them via text to come to the scene. We contacted the police came out, did a police report. And at that point, the police told me at that time, contact your insurance agent the next day to file a claim. I questioned that a little bit at the time because I said, should that be something that should be covered under his insurance being a golf cart on a public road?
Okay.
I didn't go into it. I just contacted my agent. My agent then in turn said that we need to contact Mr. Klein on Monday, the June 2nd. We contacted him, asked him who his insurance company was. He would not give that information up. We then in turn, my agent found out what insurance company he was with. We filed a claim with State Farm Insurance. I have a whole list of everything that took place. I don't know if that's even applicable. I don't know if you need that or not right now. Basically, we went back and forth for a month with the claims. They finally denied it because he did not put the golf cart on his coverage. So there was no coverage on the golf cart itself being on a public road. I then in turn contacted both parties that were involved. There were two parties, Mr. Klein and Mr. Goodwin. Their kids were involved. There were 3 kids involved. Mr. Klein is the owner of the golf cart, has 1 child, yet Mr. Goodwin had 2 children that were involved. Mr. Goodwin said, I will pay half of it, and he immediately paid half of it to Depositor Auto, and the other half of the claim remained open. I contacted Mr. Klein multiple times, telling him that he could, that this claim was open, that we had an amount of $2,700, I guess something of that nature, still needed to be paid. He was more than, if he could pay it to Depositor just to keep it clean, that would be very useful. He did not respond to any of my texts, any of my emails, and we've heard nothing from him since then. There is a video that I submitted to you that shows the complete crash that took place with the juveniles. Both are juveniles.
No, we don't get to see the video.
A 12-year-old and 11-year-old that were driving the golf cart. So nothing has taken place. Half of it has been paid for. The family, the Goodwin family, paid half of it with no problem. Mr. Klein has not paid anything. And I was advised by the people that were doing the claim through I'm drawing a blank right now, but through I go through your insurance. My insurance person said at this point we'd actually had 2 claims this year or the past year regarding my children. And he said, I'm advising you, do not file a claim on this because it's only $5,000. He said, please do not file a claim on this because there's a good chance you could lose your insurance due to the other 2 claims. And the other 2 claims, let's explain, were a deer hit one of our cars and a drunk driver backed into a car of my son's at college. And so there were 2 claims that were already out there. He said, do not do this claim. I would just try to talk to people and see if they're willing to pay it. So that's where we were at. And that's,
Do you have a copy of the quote from Depositor?
yes.
Hopefully that was.
And did you need any of the pictures of the damage or anything?
If you've got pictures, that would be great. We'll take the claim of plaintiffs 1 and the pictures of plaintiffs 2. I do not have the flash drive. I'll watch it in a moment.
Okay. And it's the video ending in 241. The last minutes were 241.
Are there multiple videos?
There is. It was more just as a backup if we needed it. But 241 is the video showing the actual incident where the kids hit the car. I do have the police report here if you need it also.
I can take that in plaintiffs 3. The first pages of the Depositor were the initial quotation, and then middle is where I paid the $2,723.40 to be able to get my car out. Put the USB in right first time. Rarely do that.
What is the
And you
top
said it was
speed?
241.
What's the top speed of a golf cart? Because this guy claims he couldn't drive the car after they hit it.
241. This is the one that's coming from their left.
So you said there were 3 kids involved?
Yes. If you notice, and I don't know if you can, if you watch the first video again, a kid actually runs off.
I saw the kid running off.
He actually had a cut on his forehead and ran to his home. That was the Goodwin family that paid their portion. What the 2 kids were trying to do was switch seats as they were driving the golf cart.
Okay.
And when they went over the top of each other, it just happened to be that they hit the steering wheel and pulled straight into.
I've done that in a car a couple times and I never hit anything. Not once.
And if you listen to the actual impact, it was very loud and through the car.
Is there sound?
Yeah, there is sound to it.
Okay, I didn't have the sound.
Yeah, it's a
Okay.
they're very fortunate how it was hurt badly, because my wife's a teacher and kind of took control of the scene when she went out. And
So whose kids were, who was in control of the steering wheel? Because the police reports were back that talks about who was in control of the
Judge, are you not paying attention? Nobody was in control of the steering wheel.
steering wheel.
yes,
So you said who was in control?
it did not. I was just told that they were switching persons when it hit.
But was it the two Goodwin kids?
It was a Goodwin kid and the
and Klein.
Klein kid.
Okay.
Yeah, the youngest one is on the back. He really had nothing to do with it. That was a Goodwin kid. So the two, and the Goodwins basically said, we feel like we're responsible for half of it because our kids were involved in it. And they both agreed to pay. Basically at the scene, Mr. Klein said, we'll pay the deductible. And basically putting it on me that I had a big claim. And he held to that all along. But, you know, obviously a golf cart on a public roadway with underage kids and no insurance, that was,
Catastrophe.
to me, there should have been
That's
some
a
type of
catastrophe.
insurance on that vehicle to be liable. I have two competitive golfers, so I know that you don't get to drive a golf cart until you're 16, as much as they wanted to do it all those years. So,
Well, yeah, I've seen enough golf carts going around, but, you know, coming down Adams over to the McDonald's and all of that fun stuff, yeah. I live out that way too, a little bit farther,
okay. Yeah, we're in the Bartle neighborhood, but
right behind the library.
yeah,
Yeah. Yeah, we're off Anderson, we're farther down.
and I know that the Mr. Klein had posed different things to the insurance companies and things, and one of them was you couldn't park on the roads in the subdivision, you can park on the roads in the subdivision according to the governances, but we also have it in our governance that in our
Oh, so your car wasn't supposed to be there, sir? Criminal.
that you're not allowed to have golf carts in the subdivision. But I know St. Joe County came out with a new policy there, but doesn't it require insurance? I don't know.
I honestly don't know.
I looked at it here this morning, so the ordinance states that if you're 18 or older.
I do not know why the judge is continuing to ask questions. It's an open and closed case.
So there's one estimate for 5416, one estimate for 5446.
The final bill is the second one.
The final bill is the second.
Yes, what the portion that I think Mr. Goodwin paid half of it, and you'll see where I actually paid for it on it's about the fourth page here, was a receipt.
The receipt.
That's the portion that I had to cover in order to get the car back.
Or get the car back.
From a depositor.
I just really feel that I need a golf cart. I need to buy one. This case makes me want a golf cart so bad.
I use depositor because I've used them before and they're highly rated, and they were within 1.2 miles. I didn't have to tow my car there. I was going to tow it, but they would not pay for it.
Right.
And so my wife and I got it over there. I had a Olsen things back, but we got it over to depositor, and they just said, we'll hold it here. You should not drive this car because the wheel well was rubbing against the tire.
Yeah. Okay, anything else you'd like to know, Mr. Conley?
No, I think that's
Definitely
pretty much
okay.
straightforward. It's just, Mr. Klein just has not, communicated. He basically said he had no idea of this hearing when I had emailed him multiple times. To the email, he told me to, send some of the information to. Basically, he just hasn't contacted me back and communicated in the way back.
A little under the weather today, the court case, no breaks, no breaks, so.
Gotta read that, eh?
Yeah. Here we gotta be. All right. So the court will show judgment for the plaintiff in the amount of $2,723.40 plus court costs and a sheriff's fees incurred. We run those differently because court costs can vary depending on how you file the nature of the case. So I don't think clerks deal with all of that.
Okay.
So judgment for $2,723.40 plus court costs and sheriff's fee. Judgment will bear interest at the rate of 8% per year pursuant to statute. All right.
Thank you very much.
Thank you, sir.
Thank you. Hope you feel
Oh,
better.
yeah.
Yeah, it's just a cold.
Meat pies are delicious.
Is there anything I
but
need
not
to do from this
ketchup.
point on?
No, what I always direct people to after a judgment is filed, if you've got any questions about how the case can proceed from here on out, is to look at, we have Indiana Small Claims Manual that provides a lot of guidance even before a claim is filed, but after a claim is filed, it talks about post-judgment proceedings. There's a process you've got to follow, so you've got to wait at least 10 days to file any sort of post-judgment proceedings, and then after that, you can file to see if there's any accounts or works, jobs that can be garnished, paychecks can be garnished, bank accounts that can be held to pay some of the judgment. You can look at Small Claims Manual and details how to do that. Okay, thank you very much. Have a good day. Thank you.
I don't know, but his son's trouble. His son is in trouble. We have a pie here. I think it was created in Lancaster, Pennsylvania a long time ago, called a shoe fly pie. Has anybody else ever tried a shoe fly pie? It's kind of good. It's very, very, very sweet. All right, now we have the mom is a teacher. The dad is a police officer. And this is a divorce hearing. And it's not, they're not going to scream and yell and argue, and it's not crazy. It's just they definitely don't agree on facts.
Okay, your name for the record?
Patrick Guido.
And your name?
Abigail Guido.
All right, this is cause number 46D02-2309-TC296. So the parties each appear in person. Ms. Guido with counsel and Mr. Guido pro se. Ms. Schaffner, what's our status?
Yes, Your Honor. We had our settlement conference. We're not able to reach an agreement, and so we are scheduled for final hearing today.
Ms. Guido, are you going to represent yourself?
Correct.
All right, and are you ready to proceed?
As far as I know, yes.
And Ms. Schaffner, are you ready to proceed?
Yes, Your Honor.
Okay, you may.
I will start with Abby.
All right.
Hey,
Can
Irish,
you approach the
how are
witness stand?
Oh my God, we're twins. We're wearing the same thing to court. How
Raise your right hand.
embarrassing.
You swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth.
I do.
Thank you. Please be seated.
Please state your name.
Abigail Guido.
And Abby, you are currently married to Patrick Guido, correct?
Yes.
And when were you married?
August 17th, 2017, I believe.
Was it August 16th of 2017?
Yeah.
Okay. And you have, how many children do you have?
One.
And what is the child's name?
Gatlin Guido.
And what is Gatlin's date of birth?
4/18/23.
And you filed a petition for dissolution of marriage on or about September 14th of 2023?
Yes.
So clearly that's been more than 60 days.
Yes.
And are you pregnant?
No.
Did you adopt any children?
No.
Okay. Are you asking this court to dissolve your marriage?
Yes.
Okay. And do you believe your marriage is irretrievably broken?
Yes.
And if the court dissolves your marriage, do you want a maiden name restored to you?
Yes.
And what is that maiden name?
Peyton.
Can you spell that?
Payton.
All right. Now, parenting time. How is parenting time with Gatlin currently scheduled with father?
So we have a 4 on, 2 off schedule. So Patrick works from 2 to 10 for 4 days a week, and then he's off 2 days a week. Those 4 days I have Gatlin, the 2 days he has Gatlin. I am a teacher, so I work Monday through Friday. So if those 4 days that I have him are Monday through Friday, then he has him before he goes to work.
Okay, so when you're teaching, then dad is able to see Gatlin every day while you're working, correct?
Yes.
And when you say he works 2 to 10, is that 2P to 10P?
Yes.
Okay. And then obviously you're off in the summers.
Yes.
All right. And so dad is essentially getting his days off of work with Gatlin.
Yes.
Okay. And those days do not include any vacation days or sick days. Is that correct?
No.
Okay. Now, his days rotate. Has he provided you a schedule for 2026?
Yes.
Are you asking going forward that when he receives his schedule for the year that he provide that within 5 days?
Yes.
Now, the schedule that he provided you for 2026, did it have vacation days on it?
No.
Do you know how much time vacation father gets?
No.
Are you asking the court that you be named as the residential parent
Yes.
of Gatlin? Okay. And he's pretty much been in your custody and care for the most part since 2023, correct?
Yes.
And where do you currently reside?
646-383.
And where does father currently reside?
6.
Since September of 23, approximately how many addresses has father had?
Since 23, probably about 3 or 4.
How long has he been at 6?
On and off again, since 2023, but lived in LaPorte and then also Valparaiso.
Granny, you should say it again. You cannot be a babysitter if you're a parent. It's impossible. You're the parent.
Is the road his parents?
Yes.
Now, where is Gatlin's childcare provider located?
In Westville.
Bobby, it's divorce. There's no winning or losing. It's just a divorce hearing.
And where do you currently do the exchanges of Gatlin?
Per the court order, it's his mom's house, my house, or the babysitter.
Has that been a problem in the past, exchanges?
Yes.
Okay, what kind of problems have you had regarding exchanges?
Having him be all the way out in almost New Buffalo at Patrick's dad's house, having to drive out there to go get him after work, and being told probably an hour before I get off of work that I need to drive out there. Also,
if the baby's in my spot, that's the baby's fault.
So the apartment that he lived in for less than 30 days with his girlfriend, having to drive there, him not coming downstairs to get him, me having to go upstairs, being told that I'm going to get the police called on me for going to drop off my son, and then having to drive him back to the babysitter before work and not being late.
Okay. So you're asking that the divorce decree say that
I actually won big time in the divorce. I got a divorce.
the exchanges take place either at your house, the babysitter, or dad's house, correct?
Yes.
Okay. And you said that you would not get much notice when you had to go to New Buffalo?
No.
Okay.
Or waiting for people to drop my son off from New Buffalo, and waiting in the parking lot at work.
Now, how do you and Patrick communicate regarding Gatlin?
Through text message.
What about at close? That was the court order.
We tried doing that. I wasn't getting
I don't have to actually stomp on my cats too much. If I just say the word, that's my spot to the cats or the dog. Boom. They're gone. Hey, that's my spot. Poof. They leave right away.
notifications through it, and it wasn't sending my messages. So I did tell him to just text me because it wasn't working, and I had to figure out where our son was at.
Okay. So you're okay with communicating via text message going forward?
Yes.
Okay. Now, who has insurance on Gatlin?
Patrick does.
Do you have the insurance card?
I do. And it's only medical, not dental.
Do you know if Patrick has dental available through his work?
He has it for himself. I've been told that he can't get it for our son because it would cost more to put him on the dental insurance monthly than it would to just take him to the dentist.
Okay. Now, in terms of father's parenting time, you're okay with keeping the schedule the way it currently is?
Yes.
Okay. And that obviously maximizes the quality time that Patrick has with Gatlin, correct?
Yes.
What about holidays and special days?
For holidays, I have looked into the Indiana state guidelines, which is per our court order. There are multiple days that each one of us would get. So for example, like Thanksgiving, it would be from Wednesday to Sunday, that either custodial or the non-custodial parent gets him yearly.
Let me show you, Josh.
I would prefer to do it that one day of the holiday so we can figure out, okay, he has him on actual Thanksgiving, I can have him the night before or vice versa. So then we can make sure that we both see him for the actual holidays.
Now, Patrick is a police officer, so does he work most holidays?
Yes.
And what about legal custody, medical, education, and religious decisions? You guys keep each other apprised of medical conditions regarding Gatlin, correct?
Yes.
So joint legal custody is not a concern?
No.
Okay. Now, child support. Child support was previously ordered at $135 a week. Is that correct?
Yes.
And do you recall when Patrick started paying that child support?
I hacked into the judge's computer and I looked at what he was looking at on Amazon, Josh. And that's what he's looking at. Tutus for his hens.
I think it was April
And little
of
bunnies.
2024
I didn't see that.
or 20, no, it's 2025, I believe.
Okay. And you filed this September of 23, correct?
Yes.
Are you asking that child support go retroactive to date of filing?
Yes.
Did he provide you with any cash payments or anything from September 14th of 2023 to April 17th of 25 when you received his first child support payment through the clerk of the court?
There was, I believe, a $100 transaction that Apple paid me within that time period, and just told me this is for things for Gatlin.
Okay. So you have no objection to giving him credit for that?
Yeah.
And so if we've calculated that that's 83 weeks at $135 per week, that's $11,205 minus the 100, so $11,105. Does that sound correct?
Yes.
Okay. And you said you work, correct?
Yes.
You're a teacher?
Yes.
And your salary, one second. Your salary, correct?
Yes.
Is $1,034.78 per week based on your yearly?
1,000 what?
$1,034.78.
Yeah, that sounds about right.
Okay. And you're asking the income withholding order, any child support be paid by income withholding order,
Hold on,
correct?
I'm thinking back. So I get paid around $1,500 every 2 weeks.
But that's after taxes, correct?
Okay, yes. Okay. I didn't want to mess that up.
How do you and father handle childcare costs?
He pays on the week that he gets paid and I pay on the week that I get paid. If he doesn't go to the babysitter that week of my week, then we just ask the babysitter that Friday that we both owe. It could be more, it could be less, depending on how many days that he went that week.
So you're responsible for the week that
I get paid.
you get paid, okay?
Yeah.
So you guys are pretty much dividing the childcare, so it differs weekly?
Yes.
So we did not include that on the child support worksheet, correct?
No.
Now, in terms of out-of-pocket medical expenses, how are you guys handling those for Gatlin?
I have paid a lot of bills for Gatlin, but that was before the mandatory court order. But I haven't gotten record of that, so I'm not worried about it. But I would like, if we do get medical bills, that we divide it evenly.
Absolutely. I would marry Josh in a second. But I can't.
I'm just gonna look at it. I'm going to show you what's been marked as petitioner's exhibit 1. What is this?
That is the medical bill for when I was in the hospital, giving birth to Gatlin.
Okay, and this is still outstanding?
So the 844 is what we owed. I had it sent to collections because my things were going to his mom's house. So when I received it, I started paying on it. But I figured that we could both split this bill.
Okay, so the 844 48 should be equally divided, correct?
Yes.
Okay, I would move to the petitioner's exhibit 1.
Any objection to the court looking at exhibit 1?
No, Your Honor.
1 is admitted.
Let's talk about income tax.
Excuse me, I maintain my own car.
exemptions. Who claimed Gatlin in 2023?
I did.
You know, Josh has other qualities other than car maintenance.
What about 2024?
I did.
Cooks. He can cook.
2025?
I have not filed yet. I do want to claim him though.
Is that because the father didn't pay any child support?
Yes.
Going forward, then, would father get 2026?
Yes.
As long as he's 95% compliant in his child support obligation?
Yes.
Extracurricular activities. Is Gatlin involved? He's kind of young, but is he involved in swimming lessons or anything like that?
I do want to get him involved in T-ball this summer, which I believe it's 85 for every Friday for June and July, I believe. I do want to split that evenly.
So that's your proposal, is equally divide any extracurricular activities that you both agree upon?
Yes. Patrick did tell me multiple times that he does want to do swim lessons for Gatlin. However, $600 being split down the middle, I don't agree on that.
I don't understand. $600 for swim lessons? My uncle just pushed me in the water. Boom, swim lesson, free. $600 for swimming lessons?
So I don't know what we do about that, but
just push your kid in the water. He'll be fine.
And you will abide by the Indiana statute regarding potential
I know. JK, I'll do it for you. Okay. Pro tip, do not take swimming lessons or parenting lessons from Kathy.
location if you
Yes.
move?
Yes.
Do you agree that if you travel out of state with Gatlin, that you should provide father with an itinerary of where you're going to be staying, a phone number, address?
Yes.
Okay.
And we do that within 30 days, right? The 30 days before we leave.
Just provide an itinerary as soon as you know the trip is happening.
Yes.
Okay, you agree
I
with
just
that?
don't want to be blindsided and him be gone out of the state.
Now, you guys do not own any real estate, is that correct?
No.
And you are driving a 2018 Jeep Wrangler?
Yes.
And does that have any debt on it?
Yes.
And are you asking that the court awards you title ownership and possession of that 2018 Jeep Wrangler?
Yes.
And you agree to pay any of the debt?
Yes.
And who is that debt owed to?
Navy Federal Credit Union.
Is that in your name alone?
Yes.
And does Patrick have a 2011 Chevy Silverado truck?
Yes.
Do you know if there's any debt on that?
I believe there is.
Are you asking that he keep that 2011 Chevy Silverado and any debt thereon?
Yes.
Do you know if that's in your name as well?
I don't think it is in my name.
Is there also a 2016 Subaru
That would be right,
WRX?
Josh.
Yes.
Are you asking that the court award that to Patrick as well?
Yes.
Is there any debt on that?
Yes.
Are you asking that he be ordered to pay that debt and hold you harmless?
Yes.
Personal property, have you guys already divided all your personal property?
Yes.
So whatever is in your possession is yours, Patrick's possession is yours?
Yep.
Do you guys have any joint marital debt?
No.
So are you asking that whatever is in your name, you would keep? Whatever is in Patrick's name, he would keep?
Yes.
Do you have any retirement accounts?
Yes.
What do you have?
I am not sure what it is. It's through my job though.
And when did you start that job?
2021 or no, 2022.
So would that be a perf probably?
Probably.
And since you started in 2022, you probably would not have been vested in 2023?
No,
Do you know if Patrick has any retirement accounts?
I'm not sure.
He's a police
So are you
officer.
asking
He has
that
PERS
whatever
too.
retirement accounts you have, you each keep?
Yes.
Do you have any joint bank accounts?
No.
Are you asking that whatever's in your name you would keep? Whatever's in Patrick's name he would keep?
Yes.
The reason why the lawyer was able to say whatever is your stuff is yours and whatever his is yours is because he's pro se, so he didn't know he should object to that. But the judge isn't stupid.
Is the child support based on your income, her income, giving you credit?
Ain't no way I would agree to $600 swimming lessons. No.
A week basically, plus some holidays. That's a lot of overnights you get.
Okay.
Okay. Yes, please.
What they should do is they split extracurricular activities down the middle on agreed upon ones with a cap. So like the baseball is $89, so $45 each. There's your cap. So if you want to do any other extracurricular activities, no problem. But the most you can get from the other parent is $45, $100 maybe tops.
I'm going to show you what's been marked as petitioners 2, Abby. This is a child support worksheet that we did with your income, dad's income. He has insurance on Gatlin, so we gave him credit for the insurance.
Okay.
And then we gave him credit for the 111 to 115 overnights.
Okay.
So his child support would be $73 per week, correct?
Yes.
Okay. I would move to admit petition exhibit 2.
Any objection to 2?
No, Your Honor.
2 is admitted.
You have also have student loans, do you not?
I believe they're all paid off.
Okay.
Yeah.
So those are in your name, or they were at time of filing, you had student loans.
Yes.
Those are only your name, so you're going to keep those as well, correct?
Yes.
Okay. I don't believe I have any further questions for this witness, Your Honor.
Dad, do you have any questions for Mom?
No, Your Honor.
Thank you. You may step down.
Thank you.
I don't have any other witnesses, Your Honor.
Step forward. You raise your right hand. You swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth.
Yes.
You please be seated.
Down things changed a little bit. The story changed.
Tell me your full name.
Patrick Guido.
And Mr. Guido, you heard the testimony of your wife at this point, correct?
Correct.
What do you disagree with?
Our disagreement.
Let me make it maybe a little easier. Do you agree that she should get the 2018 Jeep Wrangler and pay any debt on it?
She should keep her Jeep and she keeps her debt. We've agreed that we keep our debts separate.
And the 2011 Silverado and the 2016 Subaru, you should keep those and pay any debt on those.
Correct.
You agree you don't have any real estate?
Correct.
Do you agree that there's no other bank accounts to divide? What about the bill for the $800 or the $700 and some dollars that's left from the medical? You agree to split that, or do you disagree?
I disagree to split that. This is the first it's been brought to my attention.
Okay, tell me why you disagree.
This is the first time I've been asked to pay for it.
Well, it's a surprise to you.
Correct.
So if it's a surprise bill from your child, you don't want to pay it? Shoo. Life owes me a lot of money.
As far as the child support and the request of $73 per week based on your income of $1,225 per week and hers of $1,034 per week, do you agree with that or disagree with that?
You said based on the number of overnights and the.
Yes, it's giving you credit for some weekly health insurance that you pay for, and it's giving you credit for overnights that you get, which total between 111 and 115, which is more than the 98 to 100 that we normally see.
Our biggest disagreement is the number of overnights.
Okay.
So,
so what are you requesting?
I'm requesting that we keep the general schedule, the 4 to 2 during the school year, and over the summer, we do 50-50. Whether I propose that we either do 3 days on, 3 days off, or we can look at my schedule because hers is completely open. We can look at my schedule and she can pick which days she wants and how she wants to go about it.
So you basically want to keep the schedule you're doing now and just split in the summer 50-50?
Correct.
Okay. What else are you requesting?
And then I'm requesting to not pay retroactive child support, to pay whatever it was from the date we started going forward. But
I just want someone to ask him one question, and no one does. Did your child need to eat food retroactively? Was your child eating food during the time you weren't paying child support? That's the only question I want to know the answer to.
I had hired a previous attorney and I had thought that there would have been a provisional child custody order or agreement to have come up before then. We have had multiple discussions about giving her money early in the beginning of the divorce. And I was consistently told how.
I'm going to object to hearsay.
You can't tell me what your attorney said.
Okay.
So you have not paid any support up to now?
When we started in April.
Of last year?
Correct.
And what are you paying per week since April of 2025?
I'm not sure it's in the provisional agreement. I feel like $123 maybe.
Every paycheck?
Every week.
And you're asking that this not go back to the date of filing, which is September of 2023.
Correct.
And tell me why.
It was a surprise bill for him.
Because her and I had discussed giving her money and I was told not to give her money.
I'm going to object.
Did she tell you not to give her money?
Abigail told me she did not want my money.
And when did this discussion take place?
In the fall of 2023.
And has she ever come to you and then said, I do want money to start now?
No.
Other than April of last year?
Correct.
What else are you requesting?
Those are my basic requests. My time with my son, and the money that she be paid.
Any questions, Ms. Schaffner?
Yes, thank you. So do you recall requesting a guardian ad litem with your previous counsel and there was an order entered at that time?
Yes.
Okay. And that's when your child support order started?
No. Not that I believe.
This was filed with the court. Order canceling March 10th, 2025, final hearing and appointing a guardian ad litem. Is that when your child support started? Right here?
Okay.
It's
And
not
then
that the
does it
woman wants
indicate
money.
issues of retroactive
It's
assessment of provisional child support, provisional child support arrearage, and the final child support figure reserved for subsequent hearing and determination by the court?
Okay.
correct?
Correct.
Okay. So it was not waived, is that correct?
Correct.
All right. And isn't it true that we have been here on multiple occasions? Mr. Weedo, we were here, you requested to continue to get an attorney, correct?
Correct.
We were here, you requested a GAL, correct?
Correct.
So you have kind of delayed this proceeding all this time. And now you want to waive the retroactivity of the child support.
The delays weren't because of me. It was because we couldn't come to an agreement on our parenting time.
Okay. So you never paid the GAL, did you?
No.
You requested it, you never paid it, but Abby did, didn't she?
GAL must be a woman wanting money.
Not that I know of.
If I told you she did and she got a refund from the GAL, would you have any reason to doubt me?
No.
And you said that you and Abby had tried to reach an agreement. So you've never told Abby, I'll agree to the terms as long as I don't have to go retroactive on child support?
In terms of what? Parenting time?
In terms of wrapping this up?
My biggest sticking point has been my parenting time.
But now it's about child support.
I've said that I will agree to, if I get my parenting time, I'll agree to whatever. But I haven't been able to get to the agreement with the parenting time.
Oh, sorry. I hope you didn't say what the lawyer just said in a text message that she can pull up right now in court.
Now, are you aware that under the Indiana parenting time guidelines, when Gatlin turns 3 in a couple months, that you will have 4 non-consecutive weeks of parenting time throughout the year?
I was aware of that last time we spoke.
Okay. So you still have to work in the summer, right?
Correct.
Okay. And mom doesn't.
Correct.
Okay. So why would you want to do summer 50-50?
No, I don't agree with you here. Of course he wants to do summer 50-50. He's the father.
When you are going to get 4 non-consecutive weeks throughout the year and mom can be home with Gatlin.
Because my issue with Gatlin was the consistency with the schedule and him going back and forth. We've done weeks where she's gone an entire week with having him for vacation, and there seems to be struggles when it comes to the back and forth with him, going extended periods without seeing either of his parent. There's also the issue that you brought up earlier. I have an everyday relationship with him. I have him every single weekday. I have him on all my days off. I see my son regularly. So when we get to the summertime,
Terry, thank
and then I go,
thank you so much.
An entire work week without seeing him, and then I see him for 2 days, and then another entire work week without seeing him, then I see him for 2 days. It causes issues with him, and I feel like it was healthier for him to continue with the regular back and forth schedule with dad and mom throughout the year.
So you're not asking for 50-50 overnights during the summer, just continue that regular schedule so you can see him.
Well, I've taken most of my summer off with the intent of fighting to get 50-50 overnights over the summer.
When did you take that time off?
Abigail was provided the schedule, and it was through the app that you had given to us on our last meeting.
When did you request that time off?
It doesn't matter.
That time off was requested earlier this year.
Okay, you heard Abigail testify that she did not have your vacation schedule.
I had provided it to her through the app. I didn't know what she had gotten and did not get through the app, and it hasn't been discussed. And I made it known to her that I had taken most of the summer off.
So you anticipate taking your 4 weeks of your extended summer or your extended parenting time all in the summer?
No, that wasn't.
So you want half the summer plus an additional 4 weeks during the year?
The way I understood the 4 weeks was every quarter of the year, you get 7 days uninterrupted with parenting time. And I had also spoke to you and her about that not being my primary concern. I am not concerned with keeping him for 7 days uninterrupted at 4 different points during the year. am more concerned with getting the 50-50 parenting time during the summer.
Thank you, Kelly.
How many weeks of vacation do you get a year?
It doesn't matter. He took his vacation to spend time with his son. I don't understand what your problem is, lawyer. He gets 50%. He gets 50-50. He's the father.
Maybe 28 days.
So 4 weeks.
Correct.
Okay. So then it sounds like you're going to take all of your vacation and your 4 weeks of extended parenting time during the summer with Gatlin. That's your plan, sounds like.
Yeah.
Because you understand that under the guidelines.
I use all my vacation on my children too. Actually, last vacation I took was in 2018.
Half of summer doesn't start until he's 5.
I didn't. We've also been.
There's no question, sir.
No, just because the lawyer
I'm gonna show you what's been marked as
stupid doesn't mean the judges.
There's 3. Can you take a look at that? That appears to be a quick payment history.
Yes.
Okay, and those are all the payments you've made to the clerk of the court.
If my husband would have asked for 60%, 70% parenting time, I would have said, yes, sir. Yes, sir.
Yes.
Okay, and are those, what's the date on the very top? When did that payment history start? To 9/1 of 23?
Correct.
To today's date?
Yes.
So what was the first date that was listed on that payment history on the left-hand side?
4/17/25.
Okay. I would move to admit petitioners 3.
Any objection to the court looking at 3?
No.
3 is admitted.
I have no further questions for this witness, Your Honor.
Anything you want to say based on the questions asked by Ms. Schaffner?
No, sir.
You may step down. Ms. Schaffner, what are you requesting as far as parenting time?
The schedule that they're following now, the 4-2 to maximize father's time off of work with Gatlin. And then under the guidelines, he would get 4 non-consecutive weeks throughout the year with Gatlin. His 50-50 summer that he wants doesn't start until.
Under the guidelines, it didn't start.
Correct. And it doesn't sound like he would even have that much vacation time anyway, especially since mom has the summer.
It doesn't matter if he has vacation time. I had my children and I worked. I worked the days that I had my children. And then I worked the day, and then I had my children on my vacation days. It doesn't matter.
Off. He can be home with Gatlin. We understand that he would be entitled to the 4 weeks of non-consecutive, provided that he give notice to mom. I think the guidelines require 60-day notice.
That's awesome, Josh.
And they follow that schedule for the holidays too, since dad works, he's a police officer and works holidays. They would just follow the schedule that they currently, except for the holiday day itself.
So even though there's been overnights and there's been parenting time, mom wants to stick to the guidelines as far as this.
Just for the extended summer, or it's not even summer, it's just extended parenting time.
Okay, and as far as child support, he's paying now $135 a week.
35, correct.
And the number is actually 73.
Correct. That would have started March of 2025. The calculation that I had given you, Your Honor, was prior to, that was when that new order went into effect for the 2 overnights. So, and that was all prior to, from September 1st of 23 to the first payment of April 17th of 25.
So what are you asking? What amount are you asking be retroactive?
The retroactive amount, Your Honor, is 11,000. Sorry, I have it in my notes. $11,105, which is giving him credit for that $100 transaction that he paid prior to that.
How do you go from 2023 to 2025 and not pay any child support except for one $100 payment? How do you do that?
And that's figuring it at 135 a week all the way back to the date of birth?
Correct, because he was not exercising that time. Yes.
Okay.
It's not date of birth, it was date of filing.
Or date of filing?
Yes.
And any response to his testimony that in the beginning, mom said she didn't want any child support?
I can call her to rebut that. That was not true. I know that has been a point of contention throughout this, that he just did not want to pay it, and that's what held up this whole entire thing.
I'd like to hear from her. Please step forward.
Yeah, this is a divorce hearing. They are married right at this moment in time in this courtroom.
Please have a seat. I'll remind you, you're still under oath. Do you understand that?
Yes.
Ms. Shelton.
Thank you. Just for the record, state your name.
Abigail Lido.
Okay. And Abigail, is it true that the retroactivity of the child support has been the biggest point of contention in this, finalizing this divorce?
Yes.
Did you ever tell Patrick, just forget it, I don't want your child support, I don't want it?
No.
In fact, it's been in part of every...
No, Josh. So in 2023 to 2025, he didn't get parenting time. He didn't get the child at all. And he didn't pay child support. And then they went to court, guardian ad litem, all that. Then he got 50-50.
Conversations we've had, correct?
Yes.
And so you have supported him without father's help since 2023.
Yes.
Let's explain the clothing situation.
I have purchased many things of clothing or shoes or personal items for Gatlin that have went over there and I have never received back. I've never even seen them again. So I'm having to go out and rebuy it or buy the new thing. So a lot of the money that I spend on Gatlin, if I do send it over, I don't see it again.
And diapers, how much are diapers? Were diapers when he was in diapers?
I would buy the big boxes, about $35 a box.
Okay. Wipes, all the things that a baby needs.
Yes. And we did have a diaper party before our son was born. All of those diapers and wipes, probably hundreds and hundreds of dollars were left with him. And I actually went and exchanged a couple sizes as well, so we could have those sizes.
Okay. So again, you don't agree that child support, the retroactivity should be waived?
Yes.
I have no further questions.
Any questions for Ms. Witness?
When you say you went and exchanged the sizes, it was you went and exchanged the sizes because you had free reign to come into the house and grab the boxes that you wanted and you went and exchanged those for the new size.
Yeah, I had to ask you to get them. I was also told one time that if I needed to come in the house that I would have to ask you, and I was invited into your house and that ended in catastrophe as well. So I never felt comfortable coming in to get them or do anything like that.
Because I asked that me and you discuss the things that were going back and forth.
Yes. And I was also, when I did ask for money one time, I was told that you had just paid your mom money. Everyone was asking you for money. You could not afford to give me money.
There was a conversation that we had earlier that I spoke about in December, I believe it was December of 23, where I was still attempting to give you money. And I was told I was a broke piece of shit road cop and that you didn't need my money. And you said it over text.
You were attempting to give me money for childcare, but it was my week to pay. So I told you that I will pay my week and you will pay your week.
Me and you've never had disagreements about childcare paying to each other because we've always paid it to Judy. So if there was discussions about money going back and forth between me and you, it was my attempts to give you money.
It was your attempt to give me money to pay the babysitter, which I had. So I paid the babysitter with my own money. That is the only time that you have tried to give me money that I have rejected it.
I have a close relationship with Judy. Why would I be trying to give you money to pay to Judy when I go to Judy's myself?
It has happened multiple times. It has.
I have no other questions, sir.
Any other questions, Ms. Schaffner?
1 second. Yeah, I have 1 minute, Your Honor.
You may.
Yo, she took 15 minutes.
And we're back on the record in cause number 46D02-2309 DC 296. Ms. Schaffner.
Thank you. So you and Patrick used app close back in 24, correct?
No.
Just text messages?
Yes.
Okay. So do you recall a conversation about you getting your things back from Patrick? And he stated, I'm not going to be paying you $5,400 in back pay. I'm not going to be giving anything back to you, when you were asking about returning items?
Yes.
Okay. And then did you respond, my lawyer told you a year ago that you will have to pay. If you didn't start paying then, I'll see you in court then. I remember that?
Yes.
So you were talking about child support?
Yes.
Does it sound like you were waiving child support back in July of 24?
No.
Did Patrick, if you can agree to start payments of the $150 a week to start now and try not to squeeze it out of me from a year ago, then I'll agree to the settlement?
Yes.
I have no further questions.
Do you have any questions?
No, sir.
Let me ask a simple question. There was the one conversation where you said he was offering money and you said, I don't need your money. And that was just with the daycare?
Yes.
Okay. There were no other conversations like that?
No.
Right. You may step down. Okay. Let me ask Dad a quick question. Dad, that conversation that you had about payment and giving Mom money, that was only the one time? There weren't multiple times?
There was multiple conversations in the beginning of our divorce about giving her money or trying to give her cash and being shot down. And so I quit making attempts to continuously give her cash or give her money. And
does that make any sense, sir? Sir, think about what you're saying. She has this kid by herself and you try to give her money and she's going to say, oh, no, don't give me that.
just figured I would deal with it when we get to court or however it's ordered.
But the only one you testified about previously was the one dealing with the daycare. That she says with daycare and you say was regular money.
I'm going to disagree with the fact that discussion was about daycare money.
I understand that, but were there more conversations other than that, or were these conversations when you were still together and just getting ready to leave or get divorced?
No, these conversations were after the divorce had been filed. That's a prominent conversation though that I can remember today.
And Mom, you disagree with that?
Yes.
All right. All right, so Ms. Schaffner, what are you requesting?
Yes, sure. I'm requesting the child support go retroactive. It doesn't make sense if Mom accepted one payment that she acknowledged for child support, but would reject any other payments. Clearly, they had a conversation in July 2024 where, he's trying to negotiate, indicating he's not going to be paying back pay. So, and that he would sign payments if it started now in 2024. So we would ask that that child support go retroactive to that date of filing, minus the $100 that she did accept for child support, that her name be restored. Do you want to go through everything, Your Honor?
No, I think everything is clear, except the thing that they disagree with really is the parenting time and then the retroactive. I mean, everything else, it seems like they're getting along with it, and it's pretty sensible. They don't have a lot of stuff.
Right.
We're not talking millions of dollars in artwork or paintings or jewelry to divide, livestock to divide, boats, to divide. We're talking, you keep your car, pay for it, you keep your car. When I get to these, the law is pretty clear. The only questions usually is there an agreement? And as Ms. Schaffner knows, not to pay support or to not have it retroactive. Otherwise it can be requested and it can be ordered. And here I've got two conflicting statements that are not really clear that would match any case law as far as an agreement about support. And then the other question for the court is, we do this, and Ms. Schaffner sees this all the time. Sometimes we stick only to the guidelines, and then sometimes there's some room to wiggle when it comes to parenting time. And here, dad's getting parenting time and getting the child on a regular basis, more than just every other weekend throughout the school, what would be the school year. Mm-hmm. The only question really for the court is this summertime. And, when you split up a 10-week summertime or 11-week, whatever school system you're in, you're only getting 4 to 5 weeks anyway. And that's what dad would be getting in the non-consecutive anyway. So really, when you come down to it, we're arguing about maybe 5 days. You know what I mean? When you really look at the math on it and look at the days. So, the question is what's fair for the court? And I tend to fall on back when I have parties that just adamantly can't agree. I tend to fall back to the guidelines just because that's why they're there and that's why we put them forth, at least at a minimum amount, and dad's already getting more amount. So what I'm left with here is kind of a mishmash of evidence and nothing super clear that gives me room to really wiggle on the retroactive. I was trying to figure out, is there a date I can go back to where mom clearly said, okay, now I want the child support. And the only date I have is all the way in July, when I think a motion was filed in 2024, but there's clear testimony that that was not the case, that it was requested prior to that. And there's testimony for dad that he just gave up because they couldn't come to an agreement. And then the text messages kind of show that they couldn't come up with an agreement. So that leaves me stuck with the retroactivity when I look at the evidence that we have. So I am going to order that you two should be divorced, that there's clear evidence that your marriage is irretrievably broken. You should be separate and individual people. A mom should have her maiden name of Peyton restored to her. Dad and mom, mom will be the residential parent. Dad will have parenting time pursuant to the schedule they're now doing. He will go for the guidelines for the summer. Like I said, when I balance out the days, we may be talking 5 extra days that we're dealing with. And you guys can always agree to an extra day or two at holidays. I mean, if you can agree, it seems like you agree on a lot of things. It's just painful right now when you're going through the divorce. Hopefully, as time passes from the divorce being finalized, things will get easier for you too. So dad will be getting the guidelines parenting time for the summer, but with the 4 weeks extended, but the 4 on 2 off schedule for the non-summer time, even though the child's not in school at this point. When the child turns 5, obviously we go to the regular parenting time schedule where it'd be half the summer, half the holidays and so forth. I understand dad's schedule. He probably gets stuck working a lot of holidays. And so that's the reason for the other parenting time. As far as the automobiles go, as testified to, each party will keep their vehicles and pay for any vehicles debt that may be on them. And refresh my recollection, Ms. Schaffner, what was the medical bill for?
The birth of the child.
Okay. That's clearly under the statute. I know dad just got hit with that today, but that's clearly something that should be split.
Judge, no, he doesn't want to pay it because he didn't know that the hospital was going to charge them for that. I don't think the hospital told him it costs money to have a baby. So that's the hospital's fault.
So that'll be equally divided because it is from the birth of the child. As far as the retroactivity, Dad will have to be stuck with the retroactivity for the child support to the date of filing, which is different, obviously, than the date of birth. And then the current child support will pick up at the $73 amount, which is what the accurate number is for today. Dad, as far as the retroactive, there's about 11 grand out there. How do you want to pay that? Are you able to pay a little bit extra per week to pay that, or how would that? I don't know what your finances is. I want to see it. I don't want to wait and just have you say I'll pay it 5 years in the future. I'd rather have it, instead of 73, have you pay $100 a week and start chipping away at it or something like that.
Right. That's I'll look at it.
And you can. Nothing stops you if you get a tax return that you want to throw $1,000 on it. You know, I mean, you can pay that down and get that liquidated as quick as you can.
Right.
But it is something that's out there, and I see it all the time in these divorces that get drug out more than a year or two, that this issue arises, and it's always an issue.
Mm-hmm.
Then I'll just say he'll pay an extra $27 per week, Ms. Schaffner, at this time to liquidate that. So it'll be $100 a week total to be paid for child support, 73 regular and 27 to start nailing down the arrearage amount. And again, that can be.
I think average cost to have a baby is like $8,000, isn't it? 8,000.
Knock down any way you can. Just make sure it's clear if it's paid through the clerk's office what it's for, because I have seen in the past, and I'm sure Ms. Schaffner's seen, where cash money's been paid and not been kept track of, and then there's an argument, well, that was for something else. It wasn't for the retroactive child support.
That's smart, Judge. Very smart.
Anything else I'm missing?
No, Your Honor.
Okay, if you put that in a form of order, Ms. Schaffner, then I'll be happy to sign it.
I will, thank you.
Your divorce will be finalized when the ink's on the paper, so it'll take a couple days for that to get done, okay? You guys have a good day.
Thanks, you as well.
Yeah, but what do you mean by average? JK. That's what I want to know. Sherry, you still paying that off? All right. I love cabbage. So, if you go to a private hospital, JK, do you have to pay for that? You're out of pocket? Okay, Josh, as soon as I said it, I knew I was wrong. The average price when I had children was $8,000, and that was 2 decades ago. So yeah, it's $15,000 to $30,000 now. It makes more sense. I knew as soon as I said it, I'm like, man, that was a while ago. I bet the prices have gone up a little bit. All right, guys, thank you so much for coming out Friday. So I'll see you in 22 hours. Yes, sir, I will. And we'll have a good stream. Behave, because judges aren't in until Monday. All right? Thanks, guys. I really appreciate it. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. a guaranteed good time.